Welcome back to PBH 275, Injury Prevention and Control. This is week 11, and this week's module is going to talk about the role that laws and consumer choices play in injury prevention. I will start by giving you a definition of public health law. Public health law is the study of the legal powers and duties of the state to protect the health of the people. Now, there's more to it than that. Public health law is also about the limitations on the power of the state to constrain the autonomy, the privacy, liberty, the proprietary or other legally protected interests of individuals for the protection or promotion of community health. There's always going to be a tension in public health law because to protect the health of the people, sometimes you have to limit the autonomy and freedom of people. And that's some of the delicate dance we're going to talk about in this module. Many of the great successes and achievements that public health has had in the past 100 years have relied heavily upon law to make them happen. We have very high rates of childhood immunization in the United States, and part of that is because of laws and regulations that state if you're going to enroll your child in a public school, or even in a private school that receives federal money, that they have to be immunized against specific childhood diseases, or they have to have a specific medical or religious exemption. Sort of like what NSHE is doing now with the COVID-19 vaccine requirements for UNLV. Improved motor vehicle safety, yes, some of it was engineering, but a lot of it was created through laws as well. Laws that limited how fast we can go, that regulations that specified how much energy absorption had to be in the crumple zones of a vehicle. There were lots of laws that came to be that improved motor vehicle safety. And probably the ultimate example of great achievements in public health that relied heavily upon law. Since 1970, we've had much safer workplaces because of the William Steiger Occupational Safety and Health Act and the establishment of OSHA and an inspection and compliance and penalty regimen for creating unsafe working environments. The government can also sort of create law, in a sense, by what they choose to fund. For example, there's a lot of screening efforts we made some great headway in public health with these screening efforts, and those have been funded by the government, and they've been sort of attached to receiving other types of benefits, like you will not get this benefit if you also don't participate in the screening program. And it's the same with certain education programs, such as the nurse home health visits that we talked about back in the infant and childhood injury lecture several weeks ago. Now, in certain populations, certain high-risk populations, or maybe populations where one or more parents have been charged with an offense, those can actually be mandated, that you have to complete this education program if you want to maintain custody of your kids, for example. And that's another example of laws that are used to improve public health. Public health laws come in a few different varieties. One of the most common varieties of public health law is what we call statutory requirements. These are enacted by governments, and these sort of tell us what we have to do. Mandatory school immunizations is an example of that. If you want to enroll in school, you have to have your mandatory immunizations, or you have to have a documented medical or religious exemption. Seatbelt use laws, like the click it or ticket programs that we have in every state in the union. You don't really have an option to not wear a seatbelt if you're riding in a vehicle. If you're caught not wearing one, you'll get a ticket. Driver's licenses that don't necessarily give you all the autonomy to do everything that a more experienced driver does the moment you get it. These are called graduated driver's licenses, and those are statutory requirements. Here's one that you maybe have not thought of, but this is a clear example of where there's a statutory requirement that is a public health law and that really helps a lot with injury prevention, and that's the mandatory use of external cause of injury coding, the ICD-10 codes that we've talked about before in this course. By using ICD-10 codes, we can injury data that's collected at various local, state, and federal public health agencies can be more uniform. We can get a better idea of when injury outbreaks are occurring and what our rates are. We can also make better international comparisons because the ICD-10 and other types of codes were developed by the World Health Organization with the idea that we would make these standardized across the world so we could get a better handle of how nations are doing with injury control and other public health factors via direct comparison. And zoning is another one. Just the government can use zoning laws in order to ensure that residential locations are not too negatively impacted by somewhat more detrimental land uses such as dumps, landfills, strip clubs, whatever the case might be. But zoning is another example of statutory requirements that come from some level of government. Another category of public health laws would be statutory prohibitions. You're not allowed to drive anywhere in the United States if your blood alcohol level is above 0.08 or 0.05 if you're in Utah. The COVID-19 pandemic has made us all acutely aware of the fact that isolation and quarantine is within the police power of the state if there's a compelling public health reason to do so. You can limit the freedom of specific people who are known or suspected of being vectors for a highly infectious disease, for example. Gun laws, though, as we've talked about, we don't have particularly robust gun laws in this country, but there are some. If you've been convicted of a felony, you cannot possess a firearm. And of course, the government at the various levels has the ability to seize or ban substances. There's also very broad regulatory programs that fall under public health law. These are things such as the Consumer Product Safety Act, which created the Consumer Product Safety Commission, and which is our basis for basically all the regulation and all the actions that take place in the U.S. to prevent dangerous and defective products from being released into the marketplace and injuring people. And of course, the Occupational Safety and Health Act, which was the founding legislation that created OSHA. When we talk about injury prevention laws, again, it's sort of like we just said with public health laws. They can either require actions or prohibit actions. And these injury prevention laws can be directed at individuals, at products, or at environmental conditions. Again, examples of injury prevention laws directed at people would be drunk driving laws, speed limits, laws against felonious assault, and other actions. Laws directed against things would be certainly motor vehicle safety standards, consumer product laws, gun restrictions, and injury prevention laws directed at places. An example of that would be that in Nevada you can conceal carry a weapon in a lot of different places, but you better not try doing that at McCarran International Airport. That's a big no-no. Mandatory fencing around swimming pools, particularly city or HOA-owned swimming pools, and then breakaway signs along highways so that if somebody runs off the road and hits a sign, it's going to break away and go under the carriage of the vehicle rather than impaling the driver or passenger through their windshield. Here are some examples of some important milestones in injury prevention law and regulation here in the United States. I'm not going to read all of them, but you'll see some things in here that should be familiar to you at this point. Like in 1966, shortly after Ralph Nader published Unsafe at Any Speed, the National Highway Safety Bureau, which would later become the National Highway Traffic Safety Administration, was established and put under the U.S. Department of Transportation. The William Steiger Occupational Safety and Health Act came in 1970. And in 1972, the Consumer Product Safety Act and also the Flammable Fabrics Act, along with a couple of other acts, came about in 1972. CAPTA, or the Child Abuse and Prevention and Treatment Act, happened in 1974. By the year 1985, all states had child passenger safety laws. This was because highway funding was tied to having these child passenger safety laws. 1993, that was when the Brady Bill was passed, which required background checks from from people that purchase firearms from federally licensed firearms dealers. And there's some other examples here you can see. I mean, a lot of what we have done in injury prevention and progress we've made has been because of laws and regulations. For those of you who are majoring in public health, this will be just a reminder and a refresher of the police powers that governments have. The government has the police powers in order to promote health, safety, and the general welfare. And in promoting health, safety, and general welfare, they have the right to take away individual freedoms. The least controversial and most accepted form of these police powers would be to prevent you from harming others. You do not have the right to inflict harm on others. And that's always existed in laws and statutes in governments all around the world. The governments also have the police power to promote the common good. This is where things like through the power of quarantine or through the power to regulate interstate commerce. This would be a case where this is one of the few federal powers that's not reserved to the states, the regulation of interstate commerce. Again, it's to make sure that there's a level and fair playing field from state to state, that states are not doing unjust and wrong things to undercut each other. Taxing and spending powers also come from governments, along with withholding powers. And these are generally accepted. People don't get very happy about quarantines, but for the most part, promoting the common good, people recognize that as a legitimate function of government. What's probably the most controversial police power is anytime that a regulation or a limitation is put in place to prevent people from harming themselves. This was one of the biggest pushbacks against seatbelt laws for many years. The idea was that, what's it matter? I'm only going to hurt myself if I get into a crash, which is not entirely true, but that was the line of thinking. Before we understood fully the dangers of secondhand smoke, this was also a reason why a lot of people pushed back against smoking regulations and limitations. So yeah, preventing people from harming themselves will probably always be the most controversial police power of government when it's used. When we talk about public health, generally the federal government has sort of an oversight and monitoring role, and also a role directly in things such as interstate actions, things that can affect multiple states. But generally, it is the states of the Union, the 50 states, each of which have their own governments, which form a republic that we call the United States. Generally, the states will have the primary role in public health. And in fact, here in the U.S., most injury prevention laws are enforced at the state level. Now, this is not always the case, but it's generally the case. What happens is that a lot of the federal agencies that were established that have injury prevention roles, many states, including Nevada, will have a state-level equivalent to that federal agency that will actually enforce the environmental laws, the workplace safety laws, the consumer protection laws, the public health laws. Now, if you're going to have a state-level equivalent to one of these federal agencies, it has to be at least as effective as the federal agency. If it is not, those state-level agencies can lose their accreditation temporarily or permanently. When I was working many years ago in the North Carolina State OSHA office, when I had gotten hired there, they were just coming out of a period where they had lost their state accreditation for a brief time because of it was actually because of the aftermath of that Imperial Foods disaster that I talked about back during the occupational injuries lecture. And so for a relatively short time, the federal government took over OSHA compliance in the state of North Carolina, and until the North Carolina state plan could get back on its feet and demonstrate a certain level of competence to be able to provide these services. So what that generally means here in the state of Nevada is if you are in a workplace and somebody comes in that's going to enforce or investigate violations of EPA laws, Environmental Protection Agency laws, it's usually going to be an employee of the Nevada Division of Environmental Protection that will come and do that investigation or that inspection, that will issue reports, fines, and things like that. In all these cases, The exception would be if you're on a federal facility, such as the Nevada National Security Site or something like that, then all the federal agencies have jurisdiction over those. It's the same with most workplaces in Nevada that are not on federal property. If you get an OSHA inspection in the state of Nevada at like a restaurant or something, it's probably somebody from the Nevada Division of Industrial Relations, because again, this is a state level equivalent to the federal agency that enforces, and they have to enforce just as effectively as the federal agency would. And Nevada's got its own Department of Health and Human Services as well, which is sort of the state level equivalent of the U.S. Department of Health and Human Services. As I said in the previous slide, in the United States, most of the public health and injury prevention laws are sort of enforced and carried out at the level of the state government. And state governments are kind of protective of that power that they have. They can delegate some of it to smaller local governments, such as city and county level governments, but there's a couple different ways that this police power of the government is shared or not shared between state governments and then city, county, and other local governments. There are some states that follow what's called Dillon's Rule, named for U.S. Circuit Court Judge John Forrest Dillon, who back in 1868 was quoted as saying in one of his decisions, "Municipal corporations," which basically means cities or a city-county equivalent merged government or something like that, a municipal corporation owes their origin to and derive their powers and rights wholly from the state legislature. It breathes into them the breath of life, without which they cannot exist. As it creates, so may it destroy. If it may destroy, it may abridge and control. What this means from a practical sense is that a state that follows sort of Dillon's rule for governance will limit the power that local, meaning city and county governments, have to administer public health or injury prevention laws that differ from the state laws. You might remember we talked about this earlier with the Nevada concealed carry weapon permit, that the regulations on that Clark County, City of Henderson, any smaller level of governments in the state of Nevada are not allowed to deviate from the state of Nevada law on this. But there is another way that these powers can sort of be delegated, and that's through what's called home rule. What happens in home rule is that a state will give a local government authorization to carry out certain functions without legislative authority for each activity. This provides a little bit more freedom because there are some activities that are carried out at city and county and local government level that state legislatures it would be very burdensome for state legislatures to try to regulate everything that goes on at the local government level. And Nevada is what's called a home rule state, with a couple of exceptions, one of them being one of the gun laws we talked about before. But yeah, for the most part, the Clark County Commission, for example, or the Las Vegas City Council, if you're within the Las Vegas city limits here in Clark County, does have some authority to carry out certain functions, including some public health and injury prevention functions. Now, if they deviate significantly from the state laws, that's going to invite scrutiny, and it might sort of result in a reprimand or even a prohibition. But yeah, Nevada is considered to be a home rule state as of July 2015, when some additional powers were given to the Clark County Commission at that time. As a continuation of that topic of how legislatures can delegate some of their lawmaking authority to lower levels of government with certain restrictions and conditions, we also need to talk about administrative law, which is kind of in the same spirit of that. Now, though all laws in the U.S. are derived from elected legislatures, that does not mean that all laws come directly from elected legislatures. Many of our laws come from administrative agencies. The clearest example of that would be our rules for workplace safety and health here in the United States. They generally come from the administrative agency we know as OSHA, or a state-level equivalent to the OSHA, Occupational Safety and Health Administration Office. They don't come directly from Congress. If we used to ask our federal Congress every time we needed to make a slight modification to, say, the fall protection standard it would just be, that would be all they would ever spend their time on, and it would be cumbersome and unworkable. So what happens is that legislatures establish administrative agencies that are given the authority to sort of create the practical day-to-day laws and regulations that are given to those administrative agencies. Now, the legislatures established the founding laws that established the administrative agencies. The William Steiger Osh Act was a piece of federal legislation that established OSHA, which was an administrative agency. The legislature will also define the scope of that administrative agency, and this is something I'm going to talk about here in just a second. If you're wondering, are administrative laws just as powerful and just as binding as traditional legislation that comes from senators and congresspeople? The answer is yes, they are. They're just as legitimate as a source of law. However, there is one way that administrative laws can be challenged that legislative laws are not challenged in this way, and that's the concept that what was the legislative intent when they gave an administrative agency power over this area? They gave those powers within a certain scope. Is the administrative agency violating legislative intent by widening their scope? Now, we're going to get into an example of that in just a minute. This is a diagram that sort of simplifies the division of powers that we've been talking about in this lecture up to this point. And this applies to public health laws and injury prevention laws and really everything that governments do. We have a federal government who will grant, with conditions, certain powers to state, tribal, and territorial governments. We have federal administrative agencies that will grant powers to state administrative agencies under the big condition that those state administrative agencies must be just as effective as the federal administrative agency would be. We have state governments that, under certain conditions, will grant powers to city, county, and other local governments. They do this more in states that are completely home rule states. In states that have a combination of home rule and Dillon's rule, there can be more conditions put on this division of power. And we have national and state level legislatures. It's not just the federal Congress, but the House of Representatives and the Senate that are in every state as well. They make laws, but they also establish administrative agencies that do this sort of the more practical administration of workplace safety, environmental protection, consumer product safety, public health, whatever the case might be. One thing that can be said about many injury prevention laws, and this can be said about public health laws as well, is that they have been enacted over decades or even over centuries, generally in response to high-profile, often mass casualty events. But because of the way that the kind of patchwork nature of injury prevention laws, they're kind of unsystematic, and they tend to be scattered throughout countless statutes and regulations at the state and local levels. Now, there have been some efforts to consolidate these laws. Certainly, starting in 1970, we consolidated a lot of the workplace safety and health laws under one agency, the Occupational Safety and Health Administration, under the Department of Labor, and set some baseline standards so that there was no longer the patchwork of some states were really good at injury prevention at work and some states were not. So we've gotten a little bit better with that, but in a lot of, particularly with consumer injury prevention, with product liability, with things like how rigorous every state's Department of Insurance is in terms of inspecting buildings to ensure that another Triangle Shirtwaist Factory fire event doesn't happen. That is a little bit more of a patchwork. And as I said before, injury prevention laws are often reactive in nature. This is something that can be said about a lot of injury prevention and public health laws. They're written in blood. Usually some tragic thing happens which makes people aware of the need that we need to protect populations from certain risks. Sometimes the person or people who fell victim to the tragic mass casualty event will have the honor of having the law or regulation named after them. But still, this is not the best way to do injury prevention law, but that's the way that it's been done in the United States for a couple of centuries now. Just about every injury prevention law that we currently have on the books has been challenged at some point or another about its validity. Injury prevention laws are not always met with universal approval, especially when the laws will limit individual autonomy or when they will cut into corporate profits. That's just the reality that happens, and you can almost always expect there will be a challenge if you are enacting a new injury prevention law that's going to take away freedoms from some people or is going to make it more expensive to produce a product for some corporations. So basic challenges to the validity of the law can take a couple different flavors. One would be that there can be the challenge that the government lacks the constitutional authority to make a law about this. And the Constitution does spell out what the powers of government is, at both the federal and also state constitutions do this as well. Then it's just a matter of, do the courts interpret sort of those constitutions more broadly or more narrowly and prescriptive, like if it's not written in the Constitution, the government cannot do it. And that's what often happens in the case of when these things get challenged in court. Another legal challenge that a lot of injury prevention laws face is the idea that there's another legal principle that takes precedence. That if you're printing a law that says this, but then it challenges another legal principle that's maybe more long-standing, that maybe that law will not hold up to judicial scrutiny. One example of this would be when driving under the influence laws first came to be. A lot of these included checkpoints where even if you were not suspected of being under the influence, you could be stopped at a checkpoint because they do these randomly. The highway patrol will set one up, and everybody that drives by will be checked for signs of driving while impaired, maybe asked to blow into a breathalyzer if there's a question or something like that. So these DUI checkpoint laws in several different states were challenged under the Fourth Amendment. One of the bedrock elements of the Fourth Amendment is that citizens cannot be subjected to unreasonable search and seizure. When these challenges finally got to the Supreme Court, though, the Supreme Court did back the DUI checkpoint laws, and this was the quote from that Supreme Court decision. The needs of the state to prevent drunk driving accidents outweighed the minimal intrusion on sober drivers who just happened to get caught up in the DUI dragnet. Thus, the justices argued, DUI checkpoints did not constitute an unreasonable search and seizure. And as we alluded to earlier, another way that these injury prevention laws can be challenged is if they don't come directly from a legislature, but come from an administrative agency that was granted powers by a legislature. There can be the question of legislative intent. Did the legislature intend for the administrative agency to make a law like that? And I'll give you some examples shortly. Courts have generally upheld the validity of injury prevention laws because the clear public health argument can be made for why the laws need to be there. The public health, public safety, public well-being arguments are generally solid enough that the courts will uphold the validity of the injury prevention laws, but there have been a couple of notable exceptions. One would be, back in the late 1990s, the Occupational Safety and Health Administration attempted to create an ergonomics standard. If you're wondering what ergonomics is, the most practical way of defining it is it's the science of fitting a worker to the workplace. Trying to design workplaces so that they fit the worker so that, repetitive motion injuries and other sort of musculoskeletal injuries are a little bit less likely in a workplace. I mean, again, that might not be the textbook definition of ergonomics, but that's kind of the practical definition of it. And OSHA set out to create an ergonomic standard, and this was struck down under the arguments of when OSHA was founded, the legislators never intended for them to get involved in this. This is sort of the same argument that during the COVID era has been used with the Centers for Disease Control and Prevention, where the CDC has put out some regulations that establish an eviction moratorium, because there can be a big public health argument made that during a pandemic is not a time for people to be getting evicted out of their houses and apartments and rendered homeless. Of course, there have been a lot of challenges to that, and we still don't know exactly how that's going to wind up, but because a lot of people are like asking themselves, wait a second, the CDC is about infectious diseases and chronic diseases. Why are they getting involved in housing policy? So again, anytime you have a law from an administrative agency or a regulation or any kind of policy that appears to kind of go outside of the original intention of what the legislature intended for that agency to do, it's going to get challenged, and sometimes it will get struck down. And as we talked about a few weeks ago, almost any laws that help prevent firearm injuries have not been upheld. Again, because the Second Amendment is interpreted very narrowly in certain circuit courts and by the current U.S. Supreme Court. Again, if you're going to propose any sort of injury prevention legislation and it actually starts to go somewhere, there will be legal delays and roadblocks. That's an inevitable part of public health, including of injury prevention. The court's upholding injury prevention laws, for the most part, stems all the way back to the beginning of the 20th century, when it was first established through case law that the police power to protect public health is a legitimate use of government powers, that the authority of the state to enact quarantine laws and health laws of every description was granted as a result of the Jacobson versus Massachusetts decision from the early 1900s. There was a man named Henning Jacobson who had received a smallpox vaccine as a very young boy and had a not very good reaction to it. So when Jacobson challenged the requirement that he had to get a smallpox vaccination, this went all the way up to the U.S. Supreme Court. And Jacobson's argument was that his rights under both the state and U.S. constitutions were being violated. The response of the U.S. Supreme Court, again, this was based on the fact that we were dealing, in this case, with a highly infectious, contagious disease, was that the mandatory smallpox vaccination would be upheld because there are manifold restraints to which each person is necessarily subject for the common good. Many other public health and injury prevention laws have subsequently used Jacobson versus Massachusetts as their justification. So it's one thing to have the government step in and restrict the freedoms of individuals in order to protect the public from a deadly infectious disease such as smallpox. As we discussed earlier, though, the most controversial of injury prevention laws tend to be those that protect people from harming themselves, when it does not appear to be that the actions of the person is going to harm anyone else other than themselves. And this was an argument that's been made historically against seatbelt laws. And in fact, back in 1987, a man named John Hartog brought this case up after he was charged with one of those click it or ticket tickets for being pulled over and found not to be wearing his safety belt. And his case went all the way to the Iowa Supreme Court. And what John Hartog argued was that Iowa's mandatory seatbelt law protects the individual from his own foolishness, that was a quote from the case, and thus has no relation to public health. What the Iowa Supreme Court pointed out in response was that seatbelt use enhances the driver's ability to control their vehicle, thus avoiding injuries to others. This was one of the first times where a court had actually kind of affirmed some of the things that public health had been saying before, that, it's more than just you that gets protected when you put on your seatbelt. And in fact, what this case and several other subsequent interpretations said was that, and something that public health had been saying for a while, is that laws can be passed within the police power of the state to protect the public from financial loss, which can happen if somebody gets into an automobile collision and they're not wearing a safety belt. I mean, there's expenses that the public incurs from that, such as highway cleanup, the the ambulatory expenses, the medical costs, particularly if it's someone who is uninsured or underinsured, and then any unemployment and potential disability payments if somebody if they survive a collision while not wearing a safety belt, but they receive significant injuries that prevent them from being able to work. So, in order to protect the public from financial laws, courts have generally upheld that injury prevention laws may be passed within the police power of the state, even if, upon first glance, the laws appear to only protect the individual from their own actions. The laws that we have been talking about in this module up to this point have been on the criminal side of the law, meaning that for people who violate these laws, the sanctions can be getting charged with a felony or a misdemeanor, or being assessed a violation, or basically things that have to do with criminal law. We also have civil law in this country, and we also call this tort law. We have civil wrongs that are recognized by the law as grounds for a lawsuit. In this case, a person isn't going to lose their freedom if they are found to be responsible for something, but it might cost them a lot of money. Tort law is basically any sort of law where there's an injury or harm as the basis for a claim by the injured party against the party that they allege injured them or is responsible for their injury. The primary aim of tort law is to provide relief for the damages incurred from the injury and also to deter others from committing the same harms. When a person wins a tort claim against a party that they allege caused their injuries and pain and suffering, there's usually two types of damages that are awarded. Compensatory damages, which are just a monetary amount that the court deems to be equal to the amount of damage that was caused by the injurious event, and then something called punitive damages, which we'll talk about in a little bit in a future slide, and those are where the deterrence really comes in. If punitive damages are assessed, then the responsible party definitely learns to not do the same thing again that caused the harm to the person because they'll be liable once again. And tort law has been used historically to fill the gaps in injury prevention laws. They're traditionally used for things like if you get a defective product that causes you to be injured, or if you get injured through someone else's negligence. You get subjected to a fall because the state didn't put a guardrail back up on a cliffside highway or something like that. Or if you're in a car crash with somebody else driving and they are driving negligently. Or if somebody controls a dog and that dog breaks loose and bites you. I mean, these are examples of the kinds of torts that are often filed. And to fill those, we don't have criminal laws against these things, but people can pursue torts. Here in the United States, there are some limitations put on tort law or on the ability for an injured party to seek compensatory and punitive damages against a party that they believe is responsible for their injuries. One of the biggest examples of a limitation of tort law is that for the most part, on-the-job injuries are not covered under tort law. If you are in a workplace and that workplace has workers' compensation insurance, that's designed to be a no-fault system of predictable fixed compensation where if you get an injury on the job, you're awarded a certain amount of money. There's no questions asked. There's no need to take it to court. It's just that's just the system that's in place, and every state has workers' compensation laws now. And for the most part, workers' compensation is the sole remedy for people who are injured on the job. Now, there is one big exception to that. If you're on the job and your employer exhibits what's called gross negligence, in other words, the employer exhibits such a lack of care that demonstrates a reckless disregard for the safety or the lives of others. If gross negligence can be claimed, then you can actually pursue a tort claim against your employer. It's not easy to make that argument, though. For the most part, the burden of proof is very high to prove that an employer acted with reckless disregard. Sort of normal absent-mindedness or normal lack of oversight would not be considered gross negligence. So therefore, for the most part, tort law does not apply to on-the-job injuries. Here in the U.S., there's also limits on punitive damages. Again, the punitive damages are those that are assessed as punishment and deterrent for such conduct, as opposed to compensatory damages, which are more about making the person whole by figuring out how much money they are owed for their injury and then giving them that. The case that kind of set the U.S. laws in place now that limit punitive damages happened back in 1996 in the case of BMW versus Gore. This was a case that had absolutely nothing whatsoever to do with injury prevention, but it did have to do with, in this case, a person receiving a product, an automobile, that they felt was not represented correctly in terms of quality and other factors. And so they pursued a tort suit against, in this case, Bavarian Motor Works, or BMW. And they were awarded punitive damages, which, if you look back at the case, they did seem to be kind of outsized based on the injury that was being claimed by the plaintiff. So the Supreme Court, when this case got appealed up to them, they ruled that yes, this was grossly excessive punitive damages that had been awarded in this case, and that these grossly excessive punitive damages violate the Due Process Clause of the 14th Amendment, as these particular punitive damages were unreasonable, arbitrary, and capricious. So that's basically the standard that's going to be applied anytime that punitive damages are awarded by a lower court. Were those punitive damages reasonable, and did they pass the test of not being arbitrary and capricious? So yeah, there are limitations to tort law here in the U.S. Because we're talking about injury prevention laws and we're talking about laws here in the United States, I need to mention this one as well. There's one specific group that has been given protection from torts through Congress, and that is manufacturers and dealers of firearms. Back in 2005, the U.S. Congress passed the Protection of Lawful Commerce in Arms Act. What this did was it shielded gun manufacturers and gun dealers from being sued for harm that's caused by their products, basically for when their products are used in the commission of a crime. And the Protection of Lawful Commerce in Arms Act granted broad immunity to these gun manufacturers and dealers, prohibited qualified civil liability actions against gun manufacturers and dealers. The National Rifle Association, as you would imagine, if you paid close attention during the gun violence lecture, they not only supported this legislation, they were kind of the driving force of even getting it before Congress. And then after it was passed, the NRA celebrated the fact that and called it the most significant piece of pro-gun legislation in 20 years. So as we wrap up the first part of this module about the role of law in injury prevention, just a few points in summary. One is that law is one way to deal with injury and injury prevention, and injury prevention laws have been consistently upheld by courts in the United States, with a few exceptions here and there. Many public health achievements stemmed from legislation and from administrative laws that were given, from administrative agencies that were given power through legislatures. Injury prevention laws are not always met with approval. They can limit people's freedoms. They can cut into companies' profits. And the protections given by injury prevention laws can be subsequently undone when administrations change. A new administration can come in and decide that these laws are onerous and they hurt jobs or whatever the case might be, and so they're always a little bit susceptible to being undone. Tort law or civil law can fill in the gaps in injury prevention laws, but there are limits, which we just dealt with and talked about. Now let's shift our focus a little bit to the role that consumer choices play in injury prevention. Let's start by addressing the question that probably many of you had when you saw this on the syllabus or saw the announcement that this was going to be the topic of this week's module, which is, what do consumer choices have to do with injury prevention? Well, I hope that by the end of this module you'll understand what the role that they play. But consider this first. Every product that we use and consume is manufactured, grown, processed, packaged, and delivered by workers. And the workplaces that these workers are in are embedded within communities and within ecosystems. And sometimes these workplaces will dominate those communities. And also, as you'll learn from when you watch the We Buy Who Pays film, the ecosystems as well are sometimes dominated by the workplaces embedded within those communities. We have more information available to us at this point in time than ever before, and that's generally good. Supply chains are more traceable and more knowable than they've ever been before. If we wonder where a product that we use or are considering wanting to buy comes from, what are the labor practices, what are the environmental protections, where that product is grown or built or mined or whatever the case might be, this information is more known than it's ever been known in the history of commerce before. That's for both good and for bad. And every purchase that we make can be thought of as a vote. When we buy something, in a sense, we are endorsing whatever decisions brought that product to us, whatever employment decisions, whatever environmental decisions, whatever injury prevention laws and decisions brought that product to us. And I don't say this to guilt anybody. One thing I'm going to focus on in this module is, when we talk about things that we can do at the end, is that we can't evaluate every single consumer choice we make. We can't afford to research every single one. Nobody has the time for that. It would be a frustrating endeavor to even try that. But once you know these things, you can't unknow them. And so my hope is that in talking about this, for maybe one or two key things in your life, you might consider the supply chain and what the supply chain really means in terms of the real human cost of that product, and maybe make some choices that are more in line with your values based on this knowledge. In order for us to get where I want us to go in this module, I have to address an economic reality, which is that many of the products we buy come from publicly traded companies. And publicly traded companies have a lot of different goals. They have mission statement, they have value statements and things like that. But at their heart, the primary goal of every publicly traded company is to return value to their shareholders every quarter. So if you want to return value to your shareholders and have them convinced to hold on to the stock and not maybe sell it at the nearest opportunity, there's a few different ways that you can make your company more profitable in order to return value to shareholders. One would be to raise your prices. That's generally not a very popular thing for a company to want to do, because competitors can jump on that, and you have to stay competitive in this market, whatever the market is. The next way to become more profitable is to sell more. And ultimately, that's what a lot of different companies want to do. There's always going to be some boundaries to that, though. I mean, sometimes there's only so big of a market for a product or service. And there might be other companies that dominate it, and it's hard to really grow your share of it. So while that's a worthwhile goal for a company, it's not always possible to grow your market share every single quarter and have that reflected in your stock price. So the third way that companies can return value to their shareholders is by whatever the thing is, the product or the service that your company is manufacturing or offering, reduce the per unit operating costs so that more of the money that comes in can be returned to shareholders. The way you reduce the operating cost per unit is often done by outsourcing production from, for example, the United States, to other countries where wages can be less, or you can hire workers who are willing to work for lower wages. This happens here in the United States a lot with undocumented workers. Another way you can reduce your per unit operating costs is to speed up the process. This happens a lot of times in things like poultry processing plants, where there will be an attempt to speed up the production line so that every individual worker has to process several more chickens every hour. As you would imagine, the more you speed up a process, the more likely it is that people are going to get injured, so this can be very problematic. And in fact, not just speeding up the processes, but the other things that are done to reduce per unit operating costs will often translate to more dangerous working conditions. They'll result in employee disempowerment and other conditions which can increase community injury risk. This also can lead to injustices. Whenever we have vulnerable workers and vulnerable communities who are asked to bear a risk that we are not willing to bear, and I put "we" in quotation marks there because we can be defined in a lot of different ways, but basically it means that anytime that the consumer is asking other workers or the community to bear a risk that we're not willing to bear ourselves in our own community or in our own working life, injustices can result anytime that occurs. There are some business models that are just, by their very nature, exploitative and also injurious. They increase the risk of injuries for workers, for the communities around those workplaces, and in some cases for the ecosystem services and the environment that these communities rely on, and that can also lead to injury risk as well. One of the examples that I want to bring to your attention, you're going to watch a film on it. It's from the garment industry. You're going to watch the We Buy Who Pays film as part of this module. And this film tells the story of finished garments, in this case, things like shoes and clothing, other garments, that are sold in Europe and North America. But a lot of the raw materials for these goods, such as the cotton or the dyes that are used to give it different colors, and the assembly labor, all come from different regions of southern India. In these regions of India, there are laws against mandatory overtime and against child labor, but there's also virtually no enforcement of those laws. So therefore, companies owned by United States or other developed country interests often put these sorts of assembly and raw material manufacturing processes in places like southern India, because even if they have these laws on the books, they're not enforced very often. The film also talks about some of the externalities that are absorbed by the local community every time one of these businesses comes in with a promise of jobs and opportunities, and what often winds up happening. Their water systems get polluted. Their land gets polluted. The film tells the story of a coconut farmer whose land will not bear coconuts anymore because of so much of the pollution that's been put out by the companies that make the dyes that dye the cotton fabrics. There can be allostatic load and mental health issues that develop here as well, that are all absorbed by the local community where these things go on. And these externalities they're not calculated into the price of the garment or the shoe or whatever the product is. I wanted you to watch this film because I think it really shows the difficult balance that's often struck. I mean, people want to help poor folks, people that don't have a lot of economic opportunities in some of the developing nations around the world, and they think that bringing manufacturing jobs to those places might help. And yes, there is a need for jobs and opportunities in these places, but the reality on the ground of a lot of these businesses is that they bring a lot of misery. Again, like I said before, they bring a lot of negative externalities in terms of allostatic load, mental health, pollution, and there's it's not really a very good bargain for a lot of these places. So even though there's a very United States and Western centric attitude that if these manufacturing plants weren't here, these people wouldn't have the job, so isn't it better for them to have a job than not have a job? Well, just think about it. Maybe the answer is yes, these people would be better off if they didn't have these jobs and these factories embedded within their communities and their ecosystems. And it should be pretty obvious and clear at this point, too, that very little money from the purchase price of the garments or the shoes that are assembled or that are manufactured in these places comes back to the workers and their communities. Our consumer choices can have a lot of injurious effects downstream from our purchase, depending on if the business model that goes into providing that product that we choose is an exploitive and injurious one. And as we talked about when we talked about the We Buy Who Pays film, these injuries can extend beyond just the workers who are providing the product or service. Sometimes the community can be injured by the externalities that are generated by the operations. Sometimes entire nations can be damaged and destabilized and descend into civil war and chaos as a result of unbalanced economies based on trying to provide one particular product. And with that, we're going to talk about bananas, because bananas are a perfect example of the type of product that, based on the business model with which is provided to the consumer, can create a lot of downstream injuries. And a lot of the information that I'm presenting in this section about bananas comes from the Kelsey Timmerman book, Where Am I Eating? An Adventure Through the Global Food Economy. It's a very interesting book if you ever want to have an interesting public health, food systems, and environmental impacts read. The reason why I chose bananas to illustrate these business models and the impact of consumer choices is because bananas are very popular here in the United States. The average American will consume 27 pounds of bananas per year. Bananas are also very nutritious. They're a great source of vitamin C, vitamin B6, potassium, and several other micronutrients. The vast majority of bananas sold in the United States are imported. We don't really have much banana growing that occurs here in the United States. We do have very limited production in some of the warmer weather states and territories such as Hawaii, Florida, Louisiana, Puerto Rico, Guam, and American Samoa. But probably well over 99% of all bananas consumed in the U.S. are imported. And the sad and unfortunate truth is that bananas are one of the textbook examples of how meeting a consumer demand has led to great injuries, suffering, and injustice. Most of the bananas that are sold in the United States market are expected to be large and spotless, and they usually are green initially when they come into the United States, but then they ripen to bright yellow. And when they are bright yellow, that's how the consumer knows that the banana is ready to eat. There's one genetic clone of the banana that's dominant here in the U.S., and that's the Cavendish banana. And most Cavendish bananas, they have no genetic diversity whatsoever. Most of them are genetic clones of each other, which means that if we ever have a particular fusarium or other crown rot disease that Cavendish bananas are susceptible to, that can be a major destabilizing influence on our food supply. And there have been some fusarium diseases such as black sigitaka disease and tropical race 4 that have been shown to possibly be very damaging to Cavendish bananas. And the reason why we know that this type of lack of genetic diversity is a problem is because the bananas that if your parents or certainly your grandparents grew up in the United States, the bananas they consumed in their youth were not Cavendish bananas. They were the Gros Michel bananas or Big Mike bananas, and you see a picture of those on the lower right. That's what bananas used to look like in the middle to early parts of the 20th century. But then an infectious disease called Panama disease pretty much wiped out all of those bananas, and that's how Cavendish became the dominant banana. But as I've illustrated before, that only having one predominant type of banana does make the food supply a little bit susceptible. Bananas sold in the United States are expected to meet several quality criteria. There's approximately 40 consumer appearance requirements that must be met by bananas, and about 15 to 25% of all imported bananas, or all bananas that are destined to be imported, will not meet those appearance requirements. So these rejected bananas will sometimes be sold on local markets in the places where they're grown, or they will be mulched, or they will be thrown away. So that means that a lot of worker labor and a lot of ecological resources go toward things that ultimately are not consumed. Bananas have to get from the farm to the grocery store in less than 25 days in order to keep their sellable characteristics. You don't want them to have too many spots on them. They have to, the crowns have to look good. And so those bananas have to get from Costa Rica or Guatemala or Ecuador or Colombia or any other place that they're grown to our grocery stores in less than 25 days. The Kelsey Timmerman book, Where Am I Eating?, from which I got a lot of this material, focused on some of the persistent labor issues with bananas from Costa Rica, though if you looked into the banana supply chain from many other Latin American countries, you might find similar problems as well. The Costa Rican banana growers, they work for years without any kind of raises, even as cost of living increases. Any attempts to unionize or collectively bargain, particularly for the ones who work for Dole in Costa Rica, are usually met with, threats of firing and basically other anti-union efforts. So the workers are not very empowered. It's hard for the growers to make a lot of money from bananas just because the end purchasers, the supermarkets in the United States that purchase the bananas and then sell them to us, they don't pay very much for these bananas. And they also don't charge very much for them. Bananas have traditionally been what's known as a loss leader, meaning that it's something that grocery stores will often sell the bananas for less than they paid to get them, though that's not necessarily the case so much anymore. But it used to be the case in the 1970s and 80s that's what supermarkets would do. They knew that people would come in because they wanted bananas, and when they were in the supermarket or the grocery store, they would buy other things that were where the price was set above what the grocery store paid for them. So that's the concept of a loss leader. It's something that gets people in the door, but because bananas have kind of been expected to be cheap, because they were historically very cheap, especially as recently as 40 or 30 years ago, that means that the end producers of bananas are really not getting a lot of money because grocery stores aren't inclined to pay a lot for them. There's a lot of danger that goes into growing and harvesting bananas. You have to work long hours, you have to handle heavy loads, you have to deal with venomous snakes who are also very attracted to the banana crops as well. You have to use sharp machetes to sever the bananas at the crown. And you have to deal with hazardous chemicals, one of which we're going to talk about in a lot more detail later on. And the average wage of a Costa Rican banana worker who was contracted to Dole, this was back in 2013 when Kelsey Timmerman's book was written, but it's really not changed that much since then. It's about $435 per month is what a banana worker will make. What's worse is that in some of the more remote areas of Costa Rica, Standard Fruit, which is the parent company of Dole, will actually own the local grocery store as well. So therefore you have kind of one of those company store situations that you might have heard about from some of the coal mining and early labor strife here in the United States. And in that case, the workers really are squeezed, and it makes for a hazardous and disempowering work environment. When we talk about some of the fraught and dangerous labor history of bananas from some of the Central American countries that provide bananas here to the US and Canada, we have to talk about the origin of the term banana republics. And this is an insulting term that's used. It's kind of used as a blanket term now in the modern day for any kind of government that fails its citizens, that is not able to provide stable services, that has corruption and that has other forms of other indications that it is not reliably and well governed. And the term banana republic actually came from the fact that bananas had a uniquely destabilizing influence on some of the governments where bananas came to dominate the local economies. So if you want to know what are the characteristics of what we might consider to be a banana republic, which is a form of failed state, this is a pattern that's seen over and over, not just with bananas, but with many other commodity crops. First, there's a discovery that a particular crop that grows well in a region has a high demand in developed countries where maybe it doesn't grow so well. And that was the case with bananas in many Central and some of the northern South American countries. Once that discovery is made, what happens is a lot of large transnational companies will move into those countries and start buying up land. They will become the major landholders of those countries, and they will actually start to build infrastructure, such as the kind of things that governments normally do. They will build roads, they will build railroads, they'll build ports, they'll build telephone and telegraph lines, back in the days when wired communication was more of a thing. Then what happens is the republic in which these large transnational companies set up shop the economy becomes very heavily dependent on this single crop for export. Pretty much any other thing that the economy of these countries could be doing is sort of set aside in order to devote pretty much all of the resources of the country to this one crop, this one thing. And as you can imagine, that makes the country very susceptible to price fluctuations in that one thing. The end result is that you wind up with these large transnational companies sort of become the de facto government of these countries where they set up shop that grow these particular commodities such as bananas or cacao or whatever the case might be. The official governments of these countries become largely ineffective, or they form oligarchies with the dominant business elites, and they sort of form what we might call a kleptocracy, where the official government leaders get paid in order to make sure that the interests of the large transnational companies are always met. One of the consequences of running a country as a banana republic is that you tend to have a large and impoverished working class, because the nation is not running in such a way to meet the needs of its citizens anymore. The nation is run like a business now that exploits its people and its land for profit of the transnational companies that are the predominant landholders and that are, in a sense, almost the unofficial government. There's often collusion between government and business in order to keep the money rolling in. So you wind up with exploitation of public lands that should belong to the citizens of a country, for the private profit of a few, and the ecological services that are depleted for something such as bananas. They're a very ecological service intensive crop. They require a lot of fertilizers, a lot of nutrients, a lot of water, a lot of pesticides. The ecological service depletion mostly harms the impoverished working class. It's the example that we talked about from the We Buy Who Pays film, where some of the impoverished subsistence farmers in South India were being horribly damaged and injured from the exposures to all the pollutants that were also keeping them from being able to make a living. Guatemala is a very vivid example of all these factors. During the 1900s, it was discovered that, the late 1800s, early 1900s, it was discovered that people in the United States and Canada really liked bananas, that Guatemala had a really good climate for growing bananas, and so the United Fruit Company started buying up land in Guatemala starting at the turn of the 20th century, the early 1900s. By the time we got to 1950, the middle of the 20th century, United Fruit owned 70% of all the land in Guatemala and controlled the only Atlantic seaport in Guatemala, which is Puerto Barrios, pretty much the only Atlantic seaport town, because Guatemala only has a very small Atlantic coast nestled in between Belize and Honduras. In 1951, the citizens of Guatemala went to the polls and they elected Jacobo Arbenz as their new president. He ran on a reform-minded platform. He wanted Guatemala to work for Guatemalans again. and not just for United Fruit. At the time that Arbenz was elected, United Fruit was paying virtually no taxes, based on agreements signed with the previous leader. Again, some of that examples of corruption and conspiracy between the official elected government and the large transnational company, which is sort of the de facto government in situations like this. Well, Arbenz made an enemy of United Fruit with some of his reforms that he started trying to do in Guatemala. First of all, he gave all citizens in Guatemala the right to strike. There was labor reform that was passed through the legislature when Arbenz first came into power. There was also important land reform measures. 400,000 acres of land that United Fruit still owned, but was not actively growing bananas on because it was during that fallow period that has to happen with banana farming, where you have to take land out of production for a little while so that nutrient cycling can catch back up, because again, bananas are very resource intensive. Well, this land was bought back at its taxed value, which its taxed value was very low based on the fact that United Fruit had paid virtually no taxes in the years before Arbenz came into power. The goal being, by buying this land back up at what United Fruit had agreed was its tax value and returning it back to the citizens of Guatemala, that we could start making some steps toward having Guatemala for Guatemalans again. Well, of course, the powerful United Fruit Company did not like Arbenz's reform measures, and United Fruit actually appealed to the U.S. government and began a campaign to discredit the new Guatemalan government. They started a whisper campaign saying, to the CIA and other agencies in the U.S., you need to do something in Guatemala. Arbenz is a communist. And so the State Department actually labeled Arbenz and his administration communist, which at the time, this was during the communist scare of the mid-20th century, a very tragic but also silly time in the U.S. history. And the United States started a blockade of Guatemala. The people in charge of the U.S. kind of bought the United Fruit argument that this new Guatemalan government was somehow a danger to the stability of not just the banana crop, but to the United States and to capitalism. This is a really unique and troubling situation where an elected government in a sovereign nation, Guatemala, was overthrown by a U.S. blockade with limited amounts of tactical support. This government was overthrown due to a petition made to the U.S. government by a private U.S.-owned company, United Fruit. And then, after Arbenz was deposed, a new U.S.-backed pro-business and much more authoritarian government was installed in its place, which was more amenable to working with United Fruit again. Well, the citizens of Guatemala they fought back for many years against this puppet regime that had been installed to support the efforts of United Fruit. And the tragic consequence of this was that a lot of people suffered gravely. A lot of people died, over 200,000 in the next 35 years of on-again and off-again civil war in Guatemala. A lot of people were directly injured as a result of insurgencies and fighting between people representing sort of labor and land reform and leftist interests and people representing the more authoritarian and U.S. government-backed United Fruit interests. So again, in summary about this is just an example of how consumer choices and sort of not having a transparent supply chain and not thinking about supply chain issues led to just devastating consequences and destabilization and a lot of deaths, a lot of injuries, a lot of suffering. Bananas were also responsible for a huge workplace injury injustice that occurred with the workers who harvested and grew the bananas. And for that, we're going to talk about dibromochloropropanone, or DBCP, a pesticide that's used as a soil fumigant against nematodes, which these nematodes, if not treated, can attack the roots in pineapple and banana crops and cause catastrophic failure of the crops. DBCP was first developed in the U.S. in 1955. And after its development, it was sold by a few different companies, Dow, OxyChem, and Shell. Even though it had already been released in a market, the toxicological data for DBCP had not been fully gathered before it went to market. But subsequent data collected between the years 1955 and 1961, they gave rats some of this exposure to DBCP, and they found that these rats, the male rats, would show testicular atrophy and anti-spermatogenic effects. In other words, they were not able to produce sperm. It was found that both male and female rats were suffering kidney damage when exposed to DBCP. If you remember your Paracelsus, you'll know that everything can be a poison depending on dose. And it's the same with dibromachloropropane. Dose does matter. But you might think, okay, they must have given those rats a very large dose that wouldn't be emblematic of what workers might be exposed to. But no, these experiments actually somewhat tried to replicate the types of exposures that workers in a banana field might be exposed to. These rats were only given dibromachloropropane for 7 hours a day, 5 days a week, over the course of 10 weeks. So again, we're not talking about any kind of outlandish patterns of exposure. And so at different dosing points, different effects were found. When these rats were exposed to DBCP at 5 parts per million, they had an almost 19% decrease in the mean weight of their testes, which was not statistically significant, but it was certainly clinically significant. I mean, almost 19% smaller testes do not produce as many sperm as a normal size one would. When these male rats were exposed at 10 parts per million, there was this time statistically significant decrease, 49%, in the mean testes weight for male rats, and for all rats, male and female, a significant increase in kidney weight, 31.7% increase. Anytime that you've got some kind of agent that's stressing your glomerular filtration system, that sometimes shows up with enlarged kidneys. And it was found that if male rats were exposed to 20 parts per million of DBCP, they all 100% became sterile, meaning they produced no sperm whatsoever. So these toxicological findings, they were gathered between 1955 and 1961. They were published in 1961. And one of the main researchers for Shell that was doing a lot of this toxicological research, Dr. Charles Hine at UC San Francisco, sometime in the year 1960, he was actually quoted in a trade magazine saying, "If anyone wants to use a male birth control drug, I think we have identified one, but it is not very pleasant to use." So what I'm getting at here is that back in 1960, certainly by 1961, once it was officially published, it was known that at least in rats that DBCP caused male infertility. There were probably many researchers at the time who wanted DBCP to not be approved as a pesticide based on this early toxicological data. In the end, they were overruled though, because what DBCP had done is it had allowed banana crops to be much more productive than they had ever been in the past. So the companies, United Fruit, Standard Fruit, Chiquita, all these companies that were using DBCP in their Central and South American banana fields they were making money like they'd never made it before, and times were good for them. And these companies did not want this new pesticide to be unapproved by the FDA. So with the compromise that was struck was that DBCP would be registered and approved as a pesticide by the Food and Drug Administration, but there would be a workplace exposure limit applied to it of less than or equal to 1 part per million. This was, again, we're talking about 10 years before OSHA had been established, so this was still a time when workplace exposure limits were largely done piecemeal by organizations such as the FDA or private organizations such as the American Conference of Governmental Industrial Hygienists. But this was going to be the compromise, that it could still be approved and registered and used by these U.S. companies in their banana operations overseas, but they had to monitor their workers to make sure they were exposed to 1 part per million or less of it as an airborne exposure. And the reason why that level was chosen was that the lowest toxicity level in rats was 5 parts per million. Remember, that was the level at which they had about 19% reduction in testes size, but they were not infertile. They just had shrunken testes. So taking a level that was 5 times less than that, 1 part per million instead of 5 parts per million, the idea at the time was that that would be a conservative and protective level, but that it would still allow DBCP to be used on banana crops. So the registration and approval was granted by the FDA in 1961, and then the United States Department of Agriculture started approving product labeling to go on any time that these brand names of DBCP pesticides were sent overseas to these banana farms. The product labeling, which all chemicals had to have, did not mention anything about possible reproductive effects. And so for 16 years, from 1961 to 1977, this product would be manufactured and used in banana fields before the first human health effects would be noted. So the assumption had been for the previous 16 years, from 1961 to 1977, that for both the plant workers who were manufacturing this pesticide and the field workers in Guatemala and Honduras and other countries where bananas are grown, that as long as exposures were kept below 1 part per million, that everything would be fine. But all that changed in 1977. The OxyChem plant in Lathrop, California, just outside of Stockton, is where some DBCP was manufactured. Some of the workers at this Lathrop, California plant started reporting infertility concerns to their supervisors, and they thought maybe the chemicals they were working with might be responsible for this. So the National Institute for Occupational Safety and Health, which is the research arm of does research on occupational safety and health matters and is part of the CDC, they did an official health hazard evaluation. What they found was there were a total of 13 production area workers in this plant in Lathrop, California, who worked directly with DBCP. 9 of those 13 employees were fully sterile. In other words, they could not produce any sperm at all. The other 4 employees had profoundly reduced sperm counts. And the reason why this was so troubling is because there had been monitoring in this plant, industrial hygiene monitoring the whole time. The airborne levels of dibromochloropropane in this plant were always kept well below 1 part per million, but yet 9 out of 13 employees were sterile. It was believed that maybe dermal exposures might have been another way that workers were being exposed, but the point was that the existing standard, which had been first put in by the FDA and then had been adopted by OSHA in 1971 with the William Steiger Occupational Safety and Health Act, was clearly not good enough. And so OSHA issued an emergency temporary standard where the new exposure limit for dibromochloropropane would be 1 part per billion, so 1/1000th of the level that it had been before. And this was finalized in March 1978. So as of 1978, no U.S. workers who were producing DBCP could be exposed to more than 1 part per billion as an 8-hour time-weighted average. You can probably guess where this story is going. And that would be that the farmers and pesticide handlers who worked and did the labor for these U.S.-owned companies in the countries where the bananas were grown, they were not protected to the same degree. Their story starts back in 1969 when DBCP was still being used on banana fields in Costa Rica, Honduras, and Nicaragua, very widespread, because all throughout the 1960s and even in the 50s it was shown that this greatly increases yields of bananas. The export labels on these chemicals, when they came to the pesticide handlers and the farmers, did not warn of possible reproductive effects, and furthermore, they were written in English. They were not written in Spanish, which would have made them labels actually understandable to a lot of the workers. In September 1977, the U.S. Environmental Protection Agency announced that dibromochloropropane domestic distribution, meaning distribution in the United States, would be suspended under the Federal Insecticide, Fungicide, and Rodenticide Act. This meant that you could not use it on U.S. crops anymore, such as the limited U.S. bananas or in U.S. pineapples, with the only exception being a few plantations in Hawaii were given authorization to use DBCP until 1985. But in 1979, basically just only a year and a half after the EPA announced that DBCP domestic distribution will be suspended, there was a permanent ban put in place on DBCP as an agricultural pesticide in the United States. I want you to keep that year in mind, 1979. So now let's once again shift our attention to the farmers and pesticide handlers in the countries where bananas are grown in Central America. That 1979 ban on the use of DBCP in the United States did not prohibit the manufacture of DBCP, and in fact, OxyChem and Shell continue to manufacture it because the major banana interests, Standard Fruit, Chiquita, Del Monte, still wanted DBCP. It was considered essential in order to produce the amount of bananas per acre that they needed to produce to meet their production goals. And they still insisted that the toxicity risks were minor. But again, you see the situation here. This is a chemical that had been banned from use in the United States, but we were still permitted to export it and expose farmers and pesticide handlers in other companies who are working for U.S.-owned companies. They were still being permitted to be exposed to it. And in fact, Dow, another one of the companies that produced DBCP, they started to maybe grow a little bit of a conscience, and they became reluctant to sell this chemical anymore to Standard Fruit, who they'd had a contract with. Standard Fruit actually threatened the Dow Chemical Company with a breach of contract suit if they stopped selling DBCP to Standard Fruit. One of the deals that was struck between these two companies was that Standard Fruit agreed that if Dow became sued for any injuries that resulted from DBCP exposures, that Standard Fruit would indemnify them. And the sad and tragic bottom line is that DBCP, which had been completely banned from any use in the U.S. in 1979, continued to be used in Central American banana plantations until at least 1985, and was used in the Philippines until at least 1986. So many additional years of exposure happened to workers in these countries. So again, this should not come as a surprise. A lot of farmers and pesticide handlers working on bananas in Central American countries became infertile as a result of exposure to DBCP. And there were numerous court cases brought against Dole, Chiquita, Del Monte, along with Shell, Dow, and OxyChemical, the three companies that manufactured DBCP. They continue on they started around 1990, they still continue to this day. Field workers are given standing in a lot of these suits, and they can even be filed in U.S. courts because a lot of times these suits involve U.S.-owned companies and U.S.-backed companies who knowingly exposed workers to something that had been really suspected since 1961, but certainly by the time the late 70s came along, everybody knew that exposure to DBCP at relatively low levels could make males infertile. Some of the settlements that have been awarded as a result of these lawsuits have brought varying levels of justice to some of the farmers and pesticide handlers who were rendered infertile by exposure to the dibromochloropropane. And the ecological effect of DBCP still lives on in the present day, decades after it was last used in the United States, or really, thankfully, it's not used anymore in Central America either, but it's a persistent organic pollutant. There's still some underground aquifers in the Sacramento Valley of California, not too far from the San Joaquin River Valley, where a lot of these things were manufactured. You can still find dibromochloropropane at levels that exceed the Safe Drinking Water Act maximum contaminant levels. So I talked about all those facts about bananas, not because I want to make you feel guilty about enjoying bananas. That was not the point of that at all. I just did that because bananas are a very vivid and clear illustration of how consumer choices can have a big impact in injury prevention and really in public health in general, and ecological health, and ways that we try to live our values. So as we get close to the end here, some of my parting thoughts about this, please remember this. Supply chains, that's a very clinical, analytical, and impersonal phrase. But always remember that supply chains are actual people. And they're not just actual people, they're actual people who are embedded within communities and within ecosystems. When we think about the supply chains that bring us products that we use every day, we need to, if we want to be thoughtful, public health-minded people, we need to be asking ourselves, are we willing to endure the same risks from workplace or ecological injuries that we are asking the people in the supply chain for this product to endure? And for better and for worse, the age of the internet has greatly increased our ability to trace supply chains, to kind of know where our food comes from, where our shirts come from, where our cars come from, where our snack foods come from, everything like that. We can know this to a much greater degree than ever could before. And all of our buying choices are, in a sense, votes for the type of world that we want to inhabit. Now, that's a very loaded thing to say, and I want to just make this really clear right now. If you've heard nothing else in this lecture, I want you to be clear on this. We cannot realistically research every single buying choice we make. We don't have the time to do that. We don't have the budget to do that. We don't have the brain power and the cognitive ability to do that. We just cannot do that, and I'm not asking you to do that. What I am asking you to do, and it's something that I have done, is try to do a little bit better every single day. A personal challenge that I would set for each of you is think of a product that you use every day, or that you, maybe every week, something that's a very important product to you. If you have not done it before now, you should do your own little traceability research. Find out the whole entire supply chain of that product, and find out who can provide that product in a way that most represents your values and your ethics. Even if it means you have to pay a little bit more for that product, if you do that, especially if it's for something that you use a lot or something that's very meaningful to you, it will help if we all just do a little bit better. And also, as we learn about supply chains and some of the damage that happens, through exploitative governments, through ecological resource depletion, through workplace injuries, through community injuries, we can demand better from the most egregious violators. If there's particular companies whose values, despite what they might say their values are, their mission statement, if their actual lived values expressed in how things get to us through the supply chain don't reflect our values, we can choose not to support those companies. And we should choose not to support those companies. And that sends a message for them to do better. I understand and respect that the audience for this lecture, the PBH 275 students, you all are undergraduates. You might not have a lot of disposable and discretionary income. You sometimes, for the most important products that you need, you're going to be price sensitive. I understand that. That's okay. But there are certain things that once we know them, we cannot unknow them. So again, if you could take that challenge of finding, if there's one particular product that you use, love, enjoy, if you can find the one that the provider of it whose values most closely mirror yours, then that's a good thing. One thing that helps is where availability and budget allows, you should consider fair trade certified products. I don't expect somebody who's sort of struggling to pay the bills and to pay tuition and who's working their way through an undergraduate program at UNLV to buy only fair trade certified products, because they are more expensive. that's because the externalities are priced into them. If you're wondering, you've heard that term fair trade products, what does that mean? Well, with fair trade certified products, they start with an acknowledgement that existing world trade practices promote unequal distribution of wealth, but also of risk. And that if we can buy products from producers at a fair price, at a price that actually enables them to live with dignity and not have to worry so much about working extra overtime and working yourself literally to death, that's a very efficient way of promoting anti-poverty and sustainable development, much more so than traditional charity and aid. Fair trade certified products also provide dignity and respect for producers. They promote supply chain transparency, but the fair trade mechanisms are funded by higher market prices. You're going to pay more for fair trade coffee or fair trade chocolate or fair trade clothing than you will for products that are not certified. So yes, I do not expect all of you to immediately start getting everything fair trade, but just if you can consider all the supply chain factors for one or two key products in your life, you're going to help a lot. In closing here, I'm not going to read you all of the principles of fair trade. There's anywhere you look, there's anywhere between 10 and 12 what are considered to be key principles of fair trade. And I won't read all of them, but there's a few that are kind of key that I'll talk about. One is fair payment. This means that people who are producing at what is often the poorest end of the supply chain will receive a fair price for their products, which can pay them and give them enough profit to reinvest in their communities. That there will be no forced labor or child labor. Labor exploitation is forbidden in all fair trade certified product supply chains. And these standards go beyond just prohibiting forced labor and child labor to actually addressing the root causes of forced and child labor to ensure that communities are improved and uplifted. Respect for the environment. Part of the extra premium that's paid for fair trade products, particularly agricultural products, guarantees that sustainable farming practices that don't deplete and destroy the ecosystems of the countries where these products are provided or are grown, this does not occur. They value environmental stewardship. And it creates long-term relationships and builds community. I mean, fair trade certified products, in as much as we all can try to integrate them into our lives as our budget will allow, really does improve working conditions, and it results in injury prevention and conservation of ecological resources and a more fair and just world. So that's it for this week. Let me know if you have any questions or concerns. Thanks for your attention.